5 seconds to go. Start. However, it is undeniable that there could also arise a situation wherein the investigating officer ignores or does not rely on seized documents, material, or evidence which favors the accused and fails to forward it to the magistrate as required under Section 173 CRPC, specifically subsection 6. Merely because it is not already on the record of the court cannot disentitle the accused from accessing material that may have exculpatory value. It is this gap that was recognized and addressed in the suo motu proceedings and suitably codified in the text of the draft Rule 4 by introducing a requirement of providing a list at the commencement of the trial of all documents, material, evidence, etc., seized during the course of investigation or in the possession of the prosecution, regardless of whether the prosecution plans to rely on it. The facts in Manoj having reflected such a situation of suppression of evidence that favored the accused similarly necessitated elaboration of this right. The framework that emerges by reading section 173, 207, 208 and draft rule 4 is that based on the list of statements, documents, etc. received at the commencement of the trial, the accused can seek appropriate orders under section 91 of the CRPC, wherein the magistrate on application of judicial mind may decide on whether it ought to be called for. Additionally, by virtue of section 391 of the CRPC, the appellate court, if it deems necessary, may take further evidence or direct it be taken by a magistrate or court of sessions upon recording reasoning. This safeguards the right of the accused in a situation where concern has been raised regarding evidence or material in possession of the prosecution that had not been furnished but was material to the trial and disposal of the case. By way of miscellaneous application number 505 of 2022 of 2017, this court was apprised of the fact that some states had complied and other had not complied with the directions in final order dated 20th April 2021 regarding adoption of the draft rules and amending police manuals etc. in a time-bound manner 6 months. The states were directed to comply within 8 weeks and the matter is still pending. That some high courts or governments of the states, union territories have failed to comply with this court's order and are delayed in adopting the draft rules or amending the concerned police practice manuals cannot prejudice the right of an accused to receive this list of the statements, documents, material, etc. in the possession of the prosecution, which has unequivocally been recognized. In dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, shall record its reasons and may either take such evidence itself or direct it to be taken by a magistrate, or when the appellate court is a high court, by a court of session or a magistrate. When the additional evidence is taken by the court of session or the magistrate, it or he shall certify such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. The accused or his pleader shall have the right to be present when the additional evidence is taken. The taking of evidence under this section shall be subject to the provisions of Chapter 23 as if it were an inquiry by this court in its final order of the suo motu proceedings itself. Further, to say that the judgment in Manoj in relation to this and the right of the accused to receive the said list of documents, material, etc. would only apply after the draft rules are adopted would lead to an anomalous situation where the right of the accused in one state prejudicially differs from that afforded to an accused in another. As stated earlier, the requirement of disclosure elaborated on in Manoj not only was premised on the formulation of draft rules but normatively premised on the ratio of the 3-judge bench decision in Manu Sharma Supra. In these circumstances, the proper and suitable interpretation of the disclosure requirement in Manoj Supra would be that it applies at the trial stage after the charges are framed. The court is required to give one opportunity of disclosure, and the accused may choose to avail of the facility at that stage. In case documents are sought, the trial court should exercise its discretion, having regard to the rule of relevance in the context of the accused's right of defense. If the document or material is relevant and does not merely have remote bearing to the defense, its production may be directed. This opportunity cannot be sought repeatedly. The trial court can decline to issue orders if it feels that the attempt is to delay. At the appellate stage, the rights of the accused are to be worked out within the parameters of Section 391 CRPC. Order dated 20th April 2021 in suo motu WP Criminal Number 1 of 2017 reported as Criminal Trials Guidelines regarding inadequacies and deficiencies in RE versus State of Andhra Pradesh and others 2021 10 SCC 598. Stop.